The morning of October 14th began the way most Tuesday mornings began on the campus of Hartwell University. The October air carried the cold particular to that part of Ohio, sharp and clean, and carrying the smell of wet leaves and old stone. The elm trees that lined the main academic corridor had already begun their turn, their leaves burning orange and deep copper against the gray sky, falling in slow spirals onto the brick pathway that connected the law school to the main administrative quad. Students moved in clusters, heads down against the wind, backpacks slung high, coffee cups steaming in their hands. The kind of ordinary morning that gives no indication of what is coming. The kind of morning that looks, in retrospect, like the last moment of calm before a fault line cracks open beneath the surface of everything people thought they understood about power and law and who this country truly belongs to. Dr. Marcus Ellington walked the path from the faculty parking structure at precisely 8:47 in the morning. He walked it the same way he had walked it for 19 years, slowly, deliberately, with the unhurried authority of a man who had spent decades building something that could not be taken from him. He was 58 years old, broad-shouldered, with close-cropped silver hair and the particular kind of stillness in his bearing that only came from having spent years in rooms where silence cost money and every word carried consequence. He wore a charcoal wool overcoat, a navy suit beneath it, a leather briefcase in his left hand carrying 47 pages of lecture notes on the Fourth Amendment, 3 student papers he had annotated the night before, and a copy of a federal oversight report he had authored and was scheduled to present to the Department of Justice Subcommittee in Washington, D.C. on Friday. He had his faculty identification badge clipped to his lapel. He had his university parking permit visible in his coat pocket. He had his phone in his right hand, reviewing the morning's emails, the first of which was a congratulatory message from a former clerk of his who had just been confirmed to the Sixth Circuit Court of Appeals. He did not look up when the black SUV pulled to a hard stop at the edge of the brick path. He noticed it peripherally, the way a man who has lived long enough notices things without granting them attention. 2 vehicles, unmarked but unmistakably federal, the kind of black Ford Explorers with tinted windows and government plate configurations that any constitutional law professor with 2 decades in this country's courts would recognize without effort. He glanced up once. The vehicles were parked across the brick path, partially blocking the walkway between the Hartwell School of Law and the Meridian Hall Administrative Building. 3 men got out. Federal tactical vests, ICE insignia, hands already near their belts in the performative casual threat posture that enforcement agents trained themselves to project. The one in front was a man named Troy Garrison. He was 41 years old. He had been with Immigration and Customs Enforcement for 11 years. He was 6'2", pale, with the kind of jaw that looked permanently clenched, and he wore his authority the way some men wear a new jacket, with too much awareness of it, too eager to be seen in it. He had a reputation inside his unit for what his supervisor had once described in a performance review as proactive identification of enforcement targets in non-traditional environments, which was the sanitized language for what his colleagues understood more bluntly. Garrison went where others would not, stopped who others would not stop, and used the weight of the badge to do it. He stepped directly into Dr. Ellington's path. "Sir, stop. ICE enforcement. I need to see your documents." Dr. Ellington stopped walking. He lowered his phone. He looked at Garrison the way a surgeon looks at something that has gone unexpectedly wrong inside the chest cavity, not with panic, but with a very precise, very complete attention. "I beg your pardon. Your papers. Immigration documents. Proof of legal status. I need to see them now." It was not a question. It was not a request. The second and third agents had fanned out to either side, not close enough to constitute physical encirclement, but close enough to communicate that leaving was not an option being offered. Dr. Ellington looked at the badge clipped to Garrison's vest. He looked at the 2 flanking agents. He looked at the position of the vehicles. He took in all of it with the same deliberate, total inventory that he applied to every piece of evidence that had ever been placed before him in 30 years of legal work. Then he looked back at Garrison directly. "On what basis are you stopping me?" "Sir, I'm asking you a straightforward question. Do you have documentation of your immigration status?" "I am a United States citizen. I am a tenured professor at this university. I am walking to my office on the campus where I have worked for 19 years. And you have not answered my question. On what legal basis are you stopping me?" Students had begun to slow. Three of them stood at a distance, watching. A young woman with a red backpack had stopped entirely, her phone already in her hand, already recording. She was a second-year law student named Priya Okafor, and she had sat in Dr. Ellington's constitutional law seminar 6 weeks earlier when he had delivered a lecture on Terry versus Ohio and the legal limits of investigative stops, a lecture that included the line, quote, "The Fourth Amendment does not evaporate in the presence of a uniform," end quote. She recognized his voice. She recognized the geometry of what she was watching. She did not lower her phone. Garrison stepped half a step closer. "Sir, I'm going to need you to cooperate. We have a report of an undocumented individual in this area matching your description. I need documentation. ID, passport, visa, green card, anything that confirms your legal status." The words landed in the open air of the campus walkway and stayed there. Matching your description. The students who heard it understood immediately what that meant and what it did not mean. It did not mean there had been a specific report. It did not mean there was a documented complaint. It meant that Marcus Ellington was a black man in his late 50s, walking across a university campus. And that had been enough. "A report," Dr. Ellington said. The words were level. His voice had not changed pitch. "You have a report." "That's correct. Now if you'll please produce identification, I have a faculty identification badge on my lapel. I have been standing in front of you for 90 seconds. Have you looked at it?" Garrison glanced at the badge with the expression of a man who had already decided it was irrelevant. "That doesn't confirm immigration status. I need federal documentation. I am a United States citizen. I was born at Mercy General Hospital in Cleveland, Ohio, on the 14th of March, 1966. I do not carry my passport to walk across a university campus to my own office, and I am under no legal obligation to do so. What I am telling you right now is that you do not have reasonable articulable suspicion of any federal immigration violation to justify this stop, and any continued detention of me without basis constitutes an unlawful seizure under the Fourth Amendment of the Constitution of the United States." He paused. "Which I have been teaching at this institution for 19 years. Garrison's jaw tightened. Something moved behind his eyes, not doubt, not recognition, but the flicker of a man deciding to press harder when pressing harder was the only tool he trusted. "Sir, your refusal to cooperate is making this more complicated than it needs to be. We can handle this here in 2 minutes, or we can take this to a facility. You will not take me anywhere." The words came out of Dr. Ellington without elevation, without heat, with a quality that was somehow more arresting than shouting would have been. Pure, cold clarity. "You will not place me in your vehicle. You will not detain me further without legal cause. And I am advising you, very carefully, that what you are doing right now is being recorded, it is being witnessed, and you are going to want to think with extraordinary precision about your next sentence." The crowd around them had grown. 12 students now. A faculty member in a gray coat who had stopped with her arms crossed. A maintenance worker leaning against a brick pillar 30 feet away, watching. Priya Okafor had not moved. Her phone had not moved. Garrison took one more step forward. He was close enough now that the act was unmistakably a physical assertion of dominance. "Sir, I am a federal officer conducting an enforcement action. You can either cooperate or you can be placed in temporary custody pending verification of your status. That is your choice." What happened in the next 40 seconds would be described, reconstructed, and debated in federal court documents, news coverage, and congressional testimony for the following 18 months. Dr. Marcus Ellington did not step back. He did not raise his voice. He did not reach for his phone or his briefcase or attempt to walk away. He stood exactly where he was, in the same posture he had maintained from the moment the vehicles pulled up, spine straight, shoulders square, the leather briefcase hanging from his left hand. And he looked at Troy Garrison with an expression that the students who witnessed it would later struggle to describe adequately. Not anger, not fear, something quieter and far more formidable. The expression of a man who understood with total precision what was being done to him, why it was being done, what it would cost the person doing it, and who had decided with absolute clarity what he was going to do next. He reached into his coat pocket. Slowly, with deliberate, visible intention, the way a man reaches for something when he is conscious of being watched by cameras and witnesses. He removed his wallet. He opened it. He extracted his Hartwell University faculty card, the one with his photograph, his name, his title. He held it up. Dr. Marcus Ellington, Professor of Constitutional Law, Hartwell University School of Law. Room 312, Meridian Hall, 150 feet from where we are standing. He returned the card. He reached back into the same pocket and extracted a second card. He held it up. Department of Justice Civil Rights Division, Federal Oversight Advisory Panel. Appointed member. He let that card remain visible for 3 full seconds before he put it away. I have a seminar in 1 hour and 12 minutes. I suggest you move your vehicles. Garrison stared at him. Something had shifted, a small shift, barely visible, but real. The second agent to Garrison's right had gone very still. That panel membership doesn't change the requirement. I know what it changes and what it does not change, Dr. Ellington said. And so will your supervisor, and the DHS Inspector General, and the attorney representing me in the next 48 hours. He paused for exactly 1 breath. Move your vehicles. Garrison did not move them immediately. He stood for another 14 seconds, a long, terrible 14 seconds in which the only sound on that section of campus walkway was the wind through the elm trees and the distant sound of a door closing somewhere in the law school building. 14 seconds in which every person watching understood that the man in the ICE vest was deciding whether to escalate something he could not possibly win. Then he stepped back. He said something under his breath to the agent on his right. The 3 men returned to their vehicles. The SUVs pulled forward and around the corner of Meridian Hall and disappeared. Dr. Marcus Ellington stood for a moment on the brick path. He looked at the space where the vehicles had been. He looked at the students who were still there, some of whom had not yet lowered their phones, some of whom had expressions on their faces that he recognized, the particular raw expression of young people watching something confirm a thing they already knew in their bones, but had hoped was not quite as real as it appeared. He looked at Priya Okafor specifically. She was still holding her phone up. Her eyes were wet, but her hand was not shaking. "Are you all right?" she said. He looked at her for a moment. "Yes," he said. "Come to class." He picked up his briefcase, straightened his coat, and walked the remaining 150 feet to his office. Inside, he sat down at his desk. He placed the briefcase on the floor beside the chair. He put both hands flat on the surface of the desk, and he sat quietly for exactly 3 minutes. Not because he was shaken, though something had moved through him that he would not call fear, but that lived in the same neighborhood as fear, in the part of the body that remembered every black man who had not had a faculty badge and a DOJ panel membership and 40 witnesses and a recording and the knowledge of exactly what every word of the Constitution meant and where every legal pressure point was located. He sat quietly for 3 minutes because he was 58 years old, and he had spent those years building a life in which he had believed that the weight of credentials and achievement and institutional position had lifted him above precisely this kind of encounter. And he had been wrong. And he needed 3 minutes to sit with how completely, how totally, how permanently wrong he had been about that. Then he picked up his phone and called the dean of the law school. The dean, Dr. Patricia Haynes, had been in her office for 20 minutes when the call came in. She listened without interrupting. When Dr. Ellington finished, she said nothing for 4 seconds. Then she said, "I'm calling general counsel right now. Don't talk to anyone else until we've spoken in person." She hung up. She sat at her desk with her hand still on the phone. Then she did something she had not done in a professional context in 11 years. She swore. What Patricia Haynes understood in that moment, and what she began communicating with increasing urgency to Hartwell University's legal apparatus over the next 4 hours, was the following: that the man who had been stopped on her campus walkway by federal agents demanding immigration papers was not merely a tenured professor. Dr. Marcus Ellington had been a practicing constitutional litigator for 16 years before joining the Hartwell faculty. He had argued twice before the United States Supreme Court, once in a Fourth Amendment case and once in an equal protection case, both of which he had won. He had served for 9 years as a federal magistrate judge in the Northern District of Ohio before transitioning to full-time academic work. He had authored 4 books on civil liberties law, the most recent of which was currently being used as a primary text in 43 American law schools. He had been appointed 18 months earlier to the DOJ Civil Rights Division's Federal Oversight Advisory Panel, the body responsible for reviewing federal enforcement agency conduct and making recommendations to the Attorney General. He had, in his briefcase on the morning of October 14th, a report he had co-authored that was critical of aggressive ICE enforcement practices in academic environments, a report scheduled for presentation to the DOJ subcommittee in 4 days. And he had 47 witnesses. And he had video. Priya Okafor had uploaded the video to her private drive and emailed it to the law school's student newspaper editor within 20 minutes of returning to the building. The editor, a third-year student named William Farrow who had previously interned at a First Amendment legal clinic in Washington, D.C., made 3 decisions in rapid succession. He forwarded the video to the University Communications Office. He sent it to a contact at the Associated Press Regional Bureau, and he posted it to the law school's verified social media accounts with a brief, factual description of what it showed. By noon, the video had been viewed 600,000 times. By 3 in the afternoon, it had been viewed 4 million times. By that evening, it had been viewed 11 million times, and the phrase Hartwell professor was the 3rd trending search term in the United States. What people saw in the video was simple and devastating and required no commentary to comprehend. A tall black man in a charcoal overcoat, 3 federal agents in tactical vests blocking his path on a university walkway. The agent in front stepping forward, close, pressing, demanding. The black man standing still, standing completely still, his posture not defiant, not cowering, but simply unmovable, the posture of a man who knew exactly who he was and exactly where he stood and had decided that neither of those things were going to change because someone with a badge had decided to make them a question. The video cut off before the vehicles left, but what it captured was enough. By 4 o'clock on October 14th, the university had issued a statement condemning the incident and announcing a formal complaint to the Department of Homeland Security. By 5 o'clock, the president of Hartwell University, Dr. James Avery, had called a press conference on the steps of the law school. He stood at the podium in the gathering dusk with the elm trees at his back, and he said, plainly, that what had happened that morning on his campus was an abuse of federal authority, a violation of a citizen's constitutional rights, and an act that this university would pursue with every legal and institutional resource available to it. He named Dr. Ellington by name. He described his credentials with precision. He said, the agent who stopped Dr. Ellington did not know who Dr. Ellington was. That is exactly the point. It should not matter who he was. But since it apparently does, let me be very clear about who he is. In ICE's Regional Enforcement Office in Columbus, Ohio, Troy Garrison received a phone call from his supervisor, Special Agent in Charge Deborah Merritt, at 4:47 in the afternoon. The call lasted 6 minutes. At the end of it, Garrison was placed on administrative leave pending an internal review. He drove home in his personal vehicle, a gray Chevy pickup, and sat in his driveway for a long time before going inside. He had made, in his 11 years with ICE, 1,247 documented enforcement contacts. He had 38 formal complaints on file against him, the vast majority of which had been dismissed or unresolved through the standard administrative process, the slow bureaucratic machinery that processed grievances and produced findings and then filed them. He had been the subject of 2 previous civil rights inquiries, both of which had stalled. He had, in those 11 years, been promoted twice. He had received a commendation for what his supervisory chain had described as aggressive pursuit of enforcement priorities. He had done all of this within a system that had, for 11 years, told him by its silence and its rewards that what he was doing was acceptable. That system had, on the afternoon of October 14th, run out of capacity to absorb what he had done. Marcus Ellington spent the afternoon in a series of meetings with university counsel, with the dean, with the university president, and with an attorney named Judith Crane who had flown in from Washington, D.C., on the first available flight after she saw the video at noon in her office at Crane, Mosser & Associates, a civil rights litigation firm she had founded 12 years earlier. Judith Crane was 53 years old, had previously served as a trial attorney in the DOJ Civil Rights Division, and had brought 17 successful civil rights actions against federal agencies. She had a reputation in the legal community that could be summarized as follows. She did not lose cases she chose to take. She chose Marcus Ellington's case at approximately 12:45 in the afternoon from a chair in her Washington office with a cup of cold coffee on her desk and the video playing on her laptop screen. She arrived at Hartwell University at 4 in the afternoon. She and Dr. Ellington met for 2 hours in the law school conference room. When they emerged, Dr. Ellington was composed and quiet, and Judith Crane had the expression of a woman who had just been handed a case that would define a chapter of federal civil rights litigation. "We are filing," she said to the dean, simply. "We will be ready to file within 60 days. The complaint, when it was filed 61 days later in the United States District Court for the Southern District of Ohio, was 94 pages long. It named Troy Garrison as the primary defendant. It named his supervisor, special agent in charge Deborah Merritt, for failure of adequate supervision given the prior complaint history. It named the ICE Regional Enforcement Office under the doctrine of supervisory liability. It named the Department of Homeland Security as an institutional defendant. The claims included Fourth Amendment violation, unlawful seizure without reasonable articulable suspicion, 14th Amendment violation, racial discrimination in the exercise of federal authority, civil rights violations under 42 U.S.C. Section 1983, intentional infliction of emotional distress, and it sought damages in the amount of $5,900,000. The number was not symbolic. Judith Crane had calculated it from the documented cost of what the encounter had done and what it represented, compensatory damages for the unlawful seizure and its immediate consequences, for the emotional and psychological harm, for the reputational disruption in the weeks that followed, for the compounded public exposure of a private citizen to millions of viewers in a moment of enforced humiliation, and punitive damages, calculated deliberately to exceed the point of institutional discomfort, to be large enough that no agency, no supervisor, no administrator within the enforcement apparatus could look at the number and file it as a routine line in a settlement budget without feeling it. The news of the lawsuit broke on a Wednesday morning and occupied the top 3 slots of every major national news outlet by noon. By the following morning, it was international. Legal commentators spent 48 hours on live television dissecting the complaint. Civil rights organizations issued statements. Congressional representatives from both parties, though with notably different emphasis, issued statements. 3 senators called for a formal inquiry into ICE enforcement practices in academic settings. 2 things happened within the first week after the complaint was filed that changed the nature and scope of what this case was going to become. The first was the emergence of additional witnesses. 47 students and faculty had been present in some capacity during the incident on October 14th. 29 of them had already given written statements to University Counsel. But the filing of the lawsuit triggered a different kind of disclosure. 8 other individuals came forward, not from the Hartwell campus, but from other locations, other encounters, other instances involving Troy Garrison, a Mexican-American graduate student from Ohio State who had been stopped by Garrison off campus 18 months earlier and detained for 2 hours before being released without charge. A Guatemalan restaurant worker who had been detained at a bus stop in a strip mall parking lot with insufficient legal basis, detained for 6 hours, and whose detention paperwork Garrison had filed with factual inaccuracies. A Haitian-American woman, a United States citizen, born in Miami, Florida, who had been stopped outside a library branch in Columbus and interrogated about her status for 35 minutes while her 9-year-old daughter stood beside her. She had filed a complaint. It had been dismissed. She came forward now with her original complaint documentation, her daughter who was now 11 years old, and the recorded testimony of 3 bystanders who had been present and never been contacted by investigators. The second thing was what happened inside the ICE regional office itself. The internal review launched after the Ellington incident was conducted by a team from DHS's Office of Inspector General, and it was, unlike previous reviews, not a process insulated from external pressure. The OIG team arrived with the awareness that this investigation was going to produce a public report, that the public report was going to be read by members of Congress and their staff, and that the standard institutional softening of findings was not going to be viable in this environment. They pulled Garrison's full enforcement record. They pulled the records of the agents who had been with him on October 14th. They pulled the unit's overall enforcement activity log for the preceding 3 years. What they found in those logs was not the anomaly of one aggressive agent operating outside the norm of his unit. What they found was a unit in which aggressive, demographically targeted enforcement stops had become standard practice, documented internally with language that was, to the OIG reviewers, plainly euphemistic, community presence operations, targeted area sweeps, high-probability contact protocols, language designed to describe racially targeted stops in terms that did not acknowledge what they were. The OIG team also found, in the unit's internal communications, something that had not been anticipated, and that caused the lead investigator to sit very still at the table in the conference room of the Columbus field office and reread what he was looking at 3 times before he spoke. It was a series of internal emails from 3 years earlier, authored by a supervisor above Deborah Merritt, in which enforcement units were explicitly encouraged to prioritize stops in what the emails referred to as non-traditional enforcement environments, university campuses, transit corridors, commercial districts, specifically because, the emails stated, the profile of individuals likely to be encountered in those environments included higher probability undocumented populations. The emails had no statistical basis for that assertion. They had not been flagged by legal review. They had been distributed to field supervisors and incorporated into unit guidance documents. They were, in the language of the OIG investigator's eventual report, quote, facially discriminatory enforcement directives with no legal foundation and no subsequent corrective action, end quote. Deborah Merritt, when she sat down with OIG investigators in a formal interview on a gray November morning, was cooperative to a point. She was a 23-year veteran of federal law enforcement. She was precise, careful, and fully aware of the position she was in. She confirmed the contents of the emails. She confirmed they had been distributed. She said she had had concerns, but had not acted on them formally. She was asked why. She said, the culture of the unit did not encourage that kind of pushback. She said it with the flatness of someone who understood exactly how the words she was speaking would look in a report and had decided that honesty was now her only workable option. Troy Garrison hired a private attorney, a Columbus-based civil defense lawyer named Brad Hewitt, who had 15 years of experience defending federal and state law enforcement personnel. Hewitt's initial public statement was that his client had acted in accordance with his training and unit guidelines, which was a statement that the OIG report would subsequently make into an indictment rather than a defense. The first court appearance in the Ellington civil case occurred in December before Judge Catherine Wills of the Southern District of Ohio. Judge Wills was 61 years old, had been on the federal bench for 14 years, and had a reputation for patience and precision that courthouse attorneys described as absolute. She allowed the preliminary arguments to run their course and then asked the defendant's counsel a single question that drew no objection and no clear answer. If the agent's stop was based on a documented report, as counsel has claimed, can you produce that report? Silence followed. Then the response, we are still reviewing internal documentation. Judge Wills looked at counsel for 11 seconds without expression. Then she moved on. But the courtroom heard what the silence and the non-answer meant, and every reporter in the gallery wrote it down. In January, the OIG released its preliminary findings. The document was 58 pages long. It found that Troy Garrison had conducted racially motivated enforcement stops on multiple documented occasions without adequate legal basis. It found that the Columbus ICE field office had operated under internally distributed enforcement guidance that was racially discriminatory in its design. It found that formal complaints against Garrison and others in the unit had been systematically underprioritized and dismissed without adequate review. It recommended the termination of Garrison's employment, administrative action against Deborah Merritt, and a full structural review of the unit's enforcement protocols. It recommended the referral of certain individual supervisory personnel to the DOJ Civil Rights Division for potential criminal review under federal civil rights statutes. The report's release was covered on the front page of every major national newspaper. The lead paragraph of the Associated Press story read, a federal watchdog report released Thursday found that an immigration and customs enforcement agent who stopped a prominent constitutional law professor and DOJ panel member on a university campus last October had conducted a pattern of racially motivated enforcement stops, operating within a unit that distributed discriminatory enforcement guidance without legal review or corrective action. Garrison was formally terminated from ICE on February 3rd. The notification letter, delivered to his attorney, cited conduct unbecoming a federal officer, racially discriminatory enforcement practice, and failure to adhere to constitutional standards in the execution of federal duties. It was, in the dry official language of federal employment action, a permanent and total end to 11 years of a career built on doing exactly what the system had rewarded him for doing until the morning it could no longer afford to. He read the termination letter at his kitchen table on a Wednesday morning. His attorney had told him what was coming. He had had weeks to prepare for it. It did not make the moment of reading it any less final. The letter sat on the table, and he sat across from it, and neither of them moved for a long time. The two agents who had accompanied Garrison on October 14th were placed under administrative review and subsequently reassigned out of field enforcement to desk positions pending review completion. The supervisor above, Deborah Merritt, the man who had authored the discriminatory enforcement emails, resigned his position on January 28th, 6 days before the OIG report's official release date, a resignation that legal observers publicly noted was timed with the precision of a man who had been told exactly what was coming. The congressional response arrived in stages. 3 separate House subcommittee hearings were scheduled over the 2 months following the OIG report's release. The Senate Judiciary Committee launched its own inquiry, and on a cold February morning in room 216 of the Hart Senate Office Building in Washington, D.C., Dr. Marcus Ellington sat at a witness table and gave testimony before the Senate Judiciary Subcommittee on Civil Rights and Human Rights. He had been in that building before. He had testified before congressional subcommittees twice in his career. He knew the physical rhythm of it, the long table, the water glass, the nameplate, the arc of faces behind the elevated dais looking down, the cameras, the congressional staffers in chairs along the walls, the quiet before the chairman's gavel. He had testified before as an expert, as an advisor, as someone offering external analysis of legal frameworks. He had never before testified as the person the proceedings were about. He sat at the table in his charcoal suit, the same suit he had been wearing on October 14th, and he placed his written statement before him. And when the chairman recognized him and told him to proceed, he looked up from the written statement and spoke without reading it. He described the morning of October 14th. He described the stop. He described what was said and what was done. He described the moment when Garrison had told him he was being stopped because of a report of an undocumented individual matching his description, and he paused there for exactly 4 seconds, long enough for the members of the subcommittee and the reporters and the gallery to hear what 4 seconds of silence sounds like when placed next to those words. He described what the Fourth Amendment says and what it means and how it applies to every person on American soil regardless of their origin, their documentation status, their color, or what a federal agent decides in the moment their description matches their bias. He described the pattern documented in the OIG report. He described the 8 additional individuals who had come forward. He described the woman outside the library branch, standing with her 9-year-old daughter, being interrogated for 35 minutes about her right to be in this country, a country where she was born. He described the graduate student detained for 2 hours without legal cause. He described the restaurant worker detained for 6 hours on the basis of paperwork that Garrison had falsified. He did not raise his voice during any of this. He spoke with the same calibrated, unhurried precision he had spent 30 years cultivating in courtrooms, in classrooms, in the rooms where law was made and unmade. And when he was finished with the factual account, he paused once more and said, "I want to be honest with this committee about something that is uncomfortable and that I believe is essential. I am a former federal magistrate judge. I am a tenured professor of constitutional law. I am a member of a DOJ advisory panel. I have 2 Supreme Court arguments to my name. I had a crowd of 47 witnesses and a video recording within 60 seconds of that stop. I had the resources, the knowledge, the institutional connections, and the legal fluency to do exactly what I did next. Most people who are stopped the way I was stopped do not have any of those things. Most people who are stopped that way are afraid. Most people who are stopped that way have no idea what their rights are because they have been made to feel that their rights are conditional. And that is not an accident. That is a feature of how this kind of enforcement is designed to operate. It is designed to work in the silence of people who do not know they can speak, who cannot afford to speak, whose speaking will not be heard. The only reason this case exists is because I could not be silenced. The 8 other people who came forward after me could have been silenced, and very nearly were. The question this committee must answer is how many were silenced completely. How many encounters like this, like the woman outside the library, like the graduate student, like the restaurant worker, How many of those ended without a complaint, without a record, without a single official document that acknowledged the wrong that had been done? The room was quiet for the duration of those words and for several seconds after them. The chairman of the subcommittee, a senator from Illinois, was a man who had been in elected office for 22 years and who had heard thousands of witnesses deliver thousands of statements in rooms exactly like this one. He looked at Marcus Ellington without speaking for a moment. Then he said, "Thank you, Dr. Ellington. Thank you." The words were formal, but the weight behind them was something else. The civil case reached its resolution stage in April, after 4 months of pretrial proceedings, depositions, motions, and the steady accumulation of documented evidence that Judith Crane's team had assembled with the kind of methodical thoroughness that turns a strong case into an overwhelming one. The deposition of Troy Garrison, conducted over 2 days in a Columbus conference room in February, was a document of almost unreadable weight, not because Garrison was defiant, but because he was not. He answered questions with the flat effect of a man who had been told by his attorney to answer narrowly and who had, in the answering, managed to confirm essentially everything that the complaint alleged without ever using the language of confession. He confirmed the stop. He confirmed the stated basis for the stop. He confirmed that he had not reviewed any specific documented report before the stop. He confirmed that his determination was based on observable indicators. He was asked what observable indicators. He paused for 9 seconds. Then he said, "His appearance." He was asked to specify. He paused for 14 seconds. Then his attorney asked for a brief recess. The question, and the pause, and the recess were included in Judith Crane's trial brief under the heading of admissions of racial profiling. The settlement conference occurred on April 19th in Judge Catherine Wills's chambers. Both sides had known for weeks that the case was heading toward a settlement rather than a full trial. The defendant's exposure was too total, the evidence too complete, the institutional damage of a trial too significant relative to what a negotiated resolution could accomplish. The negotiation lasted 4 hours. Judith Crane did not move from her initial number for the first hour and 20 minutes. The defendant's counsel made 3 successive offers, each one higher. Each one met with the same answer until the answer changed. The settlement agreement was signed at 3:48 in the afternoon on April 19th. The total amount was $5,900,000. It included, beyond the monetary sum, a requirement that IC implement mandatory retraining protocols for all field enforcement personnel in the affected region, a requirement for independent oversight review of the Columbus Field Office's enforcement practices over the following 3 years, a public acknowledgement statement from the Department of Homeland Security, and, at Dr. Ellington's specific and non-negotiable insistence, a requirement that the case and its documented findings be used as a mandatory instructional component in all IC agent training programs nationally. Judge Wills reviewed the agreement and approved it in a brief court session on April 21st. She did not editorialize from the bench. She signed the order, looked up at both counsel tables, and said, "This agreement is approved. The court expects full compliance. We are adjourned." On the steps of the federal courthouse in Columbus, Dr. Marcus Ellington stood beside Judith Crane in the April afternoon light and faced the assembled reporters, cameras, and the small gathering of students, faculty members, and private citizens who had come to stand there. Priya Okafor was among them, standing in the second row with 3 other law students, her arms folded against the April cold, her expression something between relief and the particular determination of a young person who has watched a long fight reach its end and has understood something necessary about what the fight cost. Dr. Ellington read a prepared statement. He thanked his counsel. He thanked the university. He named the 8 individuals who had come forward and said their names aloud, one by one, into the microphones. He said that the monetary outcome of this case was not its most important outcome. He said the most important outcome was the public, documented record of what had been done and who had done it and what it had cost. He said that record could not be expunged, could not be quietly filed, could not be administratively absorbed and forgotten. He said it would exist. Then he folded the statement and placed it in his coat pocket. He looked at the reporters and the cameras and the people on the steps. "One more thing," he said. "I have been asked many times since October 14th how I felt in the moment when that agent stepped into my path. I have been asked whether I was afraid. I want to answer that honestly because I think the honest answer matters. Yes, there was fear. Not the kind of fear that makes you run. The kind of fear that comes from knowing, with absolute certainty, that the institution that is supposed to protect you has in some part decided that its protection does not extend to you, and that the only thing standing between you and everything that fear implies is your own knowledge of the law, your own voice, and whether there is someone nearby with a phone. That fear is not a personal failure. That fear is a verdict. It is a verdict on a system that has been structurally arranged to make certain people afraid in certain ways and in certain spaces, and that has, until someone is standing at a witness table or a courthouse podium or a lawsuit filing, been largely successful at keeping that verdict quiet. He paused. It is not quiet now. He stepped back from the microphones. Judith Crane answered the remaining questions from reporters. Dr. Ellington walked to the edge of the courthouse steps and stood in the afternoon light, looking at the street below, at the ordinary traffic of Columbus in mid-April, the cars and the pedestrians, and the city going about its business in the way cities do, indifferent to the particular weight of particular days. Priya Okafor came to stand beside him. She did not say anything immediately. They stood there for a moment looking at the same stretch of street. "What happens now?" she said finally. He considered the question with the same unhurried seriousness he brought to all questions. They retrain the agents. They reform the protocols. Some of them stay reformed, and some of them drift back. The institutional gravity is always pulling toward the original configuration. He paused. But there is a record now. There are 8 names in that record who were nearly not there. There will be attorneys and judges and policymakers who read that record for years. There will be students, including you, who practice law having read it. He looked at her. "That is not nothing." "No," she said. "It's not." He nodded once. He picked up his briefcase from where it rested against the stone balustrade. The same leather briefcase that had been in his hand on October 14th when the black SUVs pulled to a stop across his path. He squared his coat against the April wind and turned toward the parking structure. In the weeks following the settlement, the Congressional Subcommittee released a 41-page set of formal recommendations for reform of ICE enforcement practices, incorporating the OIG findings and the Ellington case record. The recommendations included mandatory legal review of enforcement stop protocols, new requirements for documented justification of non-workplace enforcement contacts, and a formal prohibition on the use of observable indicators as a sole basis for immigration enforcement stops. Language that the subcommittee's report noted had been used by federal agents as a documented euphemism for racial profiling in more than 300 reviewed cases. The recommendations were binding in their application to the affected office and advisory in their application to ICE nationally, but they carried the weight of public record and the political cost of being seen to ignore them. Troy Garrison, in the months following his termination, did not make public statements. His attorney confirmed that he had accepted the employment termination without formal appeal. His name appeared in federal employment records with a notation that precluded re-employment in federal law enforcement. He returned to the gray house where he had sat in the driveway after the phone call from Deborah Merritt, and he continued to live there, and the particulars of what he thought in the long months afterward were not recorded anywhere. What was recorded was his conduct record, his deposition, the OIG findings, and the settlement terms of a federal civil rights case that bore his name as the primary defendant in its first line. The supervisor who had resigned before the OIG report's release was referred to the DOJ Civil Rights Division for review under 18 U.S.C. Section 242, the federal statute governing deprivation of rights under color of law. The review was ongoing as of the close of the spring term. Deborah Merritt was formally censured, reduced in grade, and transferred to a non-supervisory administrative position in a Washington, D.C. field office. She submitted a written response to the OIG findings that contained 67 pages of detail and rebuttal and ultimately arrived at the same place her interview answer had arrived at. The culture of the unit did not encourage pushback. It was the most honest thing she had written in 23 years of federal employment, and it may also have been the most damning. On the last day of the spring semester at Hartwell University School of Law, Dr. Marcus Ellington delivered the final lecture of his constitutional law seminar. The room was full. It was always full. It had been full for 19 years, but it was fuller now, And some of the faces in the seats were not students enrolled in the course, but students who had found their way in through the edges of the room, standing along the walls, sitting on the steps of the lecture theater. He did not comment on the fuller room. He began where he always began the final lecture, with the text. He read the Fourth Amendment aloud. The whole of it. Every word. The right of the people to be secure in their persons, houses, papers, and effects, against unreasonable searches and seizures, shall not be violated. He read it slowly. He let each phrase take the time it needed. Then he put down the text. These words were written by men who had experienced, with absolute clarity, what it felt like to have authority act upon them without justification, he said. They wrote these words because they understood that the impulse of unchecked authority is always and inevitably the same. To reach further, to demand more, to define the circle of those deserving protection as narrowly as the moment allows. The purpose of these words, the reason they exist, is to make that circle as wide as the nation itself. Not wide for some, wide for all. Wide in the parking lot and wide on the campus walkway, and wide at the bus stop and wide outside the library where a woman is standing with her 9-year-old daughter. He paused. The Constitution does not know the difference between a federal judge and a restaurant worker. It was not written to know that difference. If you practice law in this country, your obligation, your irreducible, non-negotiable obligation, is to make sure that the Constitution's ignorance of that difference is honored in every room, in every proceeding, in every encounter where you have the power to honor it. That is not idealism. That is the job. The room was very quiet. The kind of quiet that settles over a space when something has been said that needs to be taken whole, not dissected, not immediately discussed, just held. He closed his notes. He looked at the room one full time. The faces near the front, the faces along the walls. Priya Okafor in the fourth row with her pen still in her hand, and her notebook open, and her expression the one he had seen on the campus walkway. The one that was not shock and not grief and not rage, but something harder than any of those. Something that was going to be there every day for the rest of her professional life, quietly informing every decision she made about what the law was supposed to do and who it was supposed to protect. Have a good summer, he said. Work hard. Come back ready. He walked out of the lecture hall and into the corridor. Through the tall windows at the end of the corridor, the elm trees along the main campus walkway were green in the May light. Students moved in clusters on the brick path below, unhurried in the warmth. The walkway looked the way it always looked. It looked like a walkway on a university campus on a warm day in late spring. It also looked like something else now. Something that had been a site of something. Something that was documented, numbered, archived, part of the legal record of this country. An ordinary walkway where an extraordinary thing had happened, or rather where an ordinary thing had happened. The kind of ordinary thing that happened every day in ordinary places to ordinary people who did not have 47 witnesses and a recording and 30 years of constitutional law practice standing between them and what comes after the black SUV stops, and where, because of a particular combination of factors that could not be replicated and should never have been required in the first place, the ordinary thing had been seen, recorded, pursued, argued, and resolved in the only language that institutions reliably understand, the language of consequence. The elm trees moved in the May wind. The students moved below on the brick path. The city of Columbus went about its ordinary Thursday afternoon, and on the 7th floor of a federal building in Washington, D.C., a clerk in the DOJ Civil Rights Division was at that moment preparing the final binding version of a 41-page enforcement reform document, a document that contained, in its second footnote, the words Ellington versus Department of Homeland Security et al., SD Ohio, April 2025, followed by a citation that would, from that day forward, sit in the body of American civil rights case law as a permanent, unretractable marker of what had been done, who had done it, and what it had cost. A document that would be read by law students and federal agents and judges and policymakers for decades. A document that began where all such documents begin, not with the law, but with the morning. A Tuesday morning in October, in a city in Ohio, with cold air and copper-colored leaves and an ordinary brick walkway, and a man walking to his office with a briefcase in his left hand, and a system that had decided, for the last time, that it could reach out and make his right to that walk a question. The system had been wrong, and now everyone knew it. And the record said so. and the record did not close.